A lot of athletes these days think they're above the law.
You're out of order! You're out of order! The whole trial is out of order!
Let's get an inside look at the legal side of sports.
Ric Calzada is my lawyer. Let My Law Solution be your law solution. He is one of the partners at My Law Solution over in Winter Park. You can check him out at mylawsolution.com. You can also give him a call at 407-843-2222. One of the reasons we have Rick on every week is because his law firm handles all facets of the law. Family law, criminal matters like DUIs, bankruptcy to protect your assets. They do it all. Rick, welcome to the show.
Good morning, gentlemen.
As always. By the way, Rick, you are a candidate for a Mikey Award this year.
Oh, really?
Did you know that?
I did not know.
Yeah, you go to 969thegame.com. You can actually vote for yourself.
Wow.
As a Mikey Award winner.
I might be the only vote.
I don't know about that. All right, Rick, you're not only a great, great lawyer, you're also a music fan, all right? I want your legal opinion of the ongoing trial where another band, I think the band's called Spirit, is suing Led Zeppelin, saying they stole the riff from Stairway to Heaven way back in 1968. Stebbin, do we have the clips? First of all, we're going to play Spirit's song called Taurus, and then we're going to play Stairway to Heaven, a riff from those, and you tell me if Taurus has a case. Stebbin, Taurus. Okay, that was Spirit in the song Taurus. Here is Led Zeppelin with a later version, Stairway to Heaven. I don't know, Rick. Sounds awfully similar to me.
But not exact.
Not exact.
Similar, but not exact. And so we have to look back. Is it something that is a chord over time? And that's Led Zeppelin's defense, that this has been a common thing that's been done for centuries.
Mm-hmm.
And so, therefore, there was nothing unique about it. And then, so the next step is, did Led Zeppelin know about that particular chord?
Mm-hmm.
No.
They toured together.
But did they know? And that's the question. So they have to prove that they actually had knowledge of it and then ripped it. And I don't think they're gonna succeed. I really don't. It's similar but not the same.
But here's the thing: it's just as similar as Blurred Lines is to that the song that Otis Redding sang. Right? So Otis Redding's song and that song were a lot more further apart than these two are. Or for that matter, a lot further apart than that Adele song Into the Deep, and
Sure.
The Rolling Stones song Gimme Shelter.
Sure.
Gimme Shelter is basically Into the Deep is a slowed down version of Gimme Shelter.
Yeah. There are only so many possible combinations in music that if you make that standard, then everybody is basically ripping everybody off. So I just don't see it falling in favor.
So you're saying not guilty?
No, well, it would be not liable.
Not liable.
Yeah.
Led Zeppelin,
Yep.
not liable.
Nope.
All right. We talked a lot about this case yesterday. I want to get your opinion. All right. There's a DA in Monroe, Louisiana. His name is Jerry Jones, not that Jerry Jones. All right. He's not moving forward and pressing charges against a star University of Alabama football player, left tackle Cam Robinson, and also another Alabama player, Lawrence Hootie Jones, because he says he didn't want to ruin the kids' lives. Here's a quote from him.
I want to emphasize once again, the main reason that I'm doing this is that I refuse to ruin the lives of two young men who have spent their adolescence and their teenage years working and sweating while we were all home under air conditioning.
Okay, that is the DA, Jerry Jones. The two players, by the way, were charged with possession of a controlled dangerous substance, some sort of drug, and Robinson was also found to be in possession of an illegal stolen gun. My question to you is this. He says he didn't want to ruin the kid's life. Is that the DA's job to save lives, or is it the DA's job to
enforce the laws of the state?
Yes.
I think it's to enforce the laws of the state. Now, there's such thing as prosecutorial discretion.
Okay.
All right. And he's obviously exercising it, but the reasons that he's exercising it seem to be more of they're football players, all right, than some sort of other mitigating factor. But his rationale that there wasn't enough evidence, there was plenty of evidence.
The gun, right?
In plain sight, according to the police report, there's a gun, there's marijuana, there's all kinds of issues here. There's plenty of evidence, but he's making a discretionary move here not to charge. When I first heard the story, I thought they were arrested in Alabama, and this is an Alabama prosecutor protecting Alabama boys.
No, but this is a hometown prosecutor protecting hometown kids.
That's exactly right.
Right,
yes.
Hometown football
yes.
players. They
yes.
probably won the state title for Monroe High School or something.
Probably a very small town.
Mm-hmm.
Prosecutors are elected, and he made a decision.
So do you think if it was a normal 22-year-old?
He would have been charged. Absolutely, because there was plenty of evidence. It's called constructive possession, all right? So when there's more than one person in an automobile and something is found in there, it's illegal. It's not actual possession, it's constructive possession. And in this case, there was plenty of evidence to suggest that both players would be charged with it, because some of the evidence was found close to one, some of the evidence was found close to another one, in plain sight, under a seat, definitely under the dominion and control of those two individuals. So they could have brought charges. Now, whether they would get a conviction is a different story, and maybe he was taking that into consideration as well.
Gotcha. All right, more rape news in college football. A Vanderbilt player by the name of Brandon Vandenberg, all right? He was convicted of rape, even though he didn't actually do the raping. We talked about this yesterday as well. He was dating a woman, a college woman, and according to the prosecutors, he plied her full of alcohol, maybe even the date rape drug. She passes out. He encourages his Vanderbilt teammates to rape her.
He did more than that. He did much more than that.
Okay.
So he basically dragged or carried her into his dorm room, had others assist him in carrying her into his actual dorm room, encouraged the individuals to rape her, allegedly passed out condoms to the individuals, filmed it, streamed it, laughed, and encouraged. That's a crime under any definition.
Is it rape, though?
It's an old English term called inchoate. All right, so he's guilty of the crime that they committed, because in Florida we would use solicitation. He solicited these individuals to commit the crime of aggravated battery.
Is it sort of like if you hire somebody to murder?
Exactly right. Exactly right. You didn't pull the trigger, but you encouraged, you paid, you solicited the individual to do that.
That's
and so
interesting.
he would have been convicted under Florida law as well for an inchoate crime, even though he didn't actually do the crime itself. He's still criminally culpable because he had the criminal intent.
Gotcha.
And that's the difference here. So if I said, you said something upset me right now, and I said, Doc, kill Bianchi.
Okay.
I didn't have the criminal intent for you to really do it. So if you did it, I don't think I would be held criminally liable for it. But when I helped carry the body, all right, I helped bring the gloves, I filmed you, and I was laughing and saying, yeah, do it. Yeah, that's a different level of intent. That's criminal intent. That's a mens rea that I wanted you to do the crime, and so I am criminally liable for it.
Is that like the same concept as felony murder? Is that an inchoate crime?
Very different. Very different, because felony murder, you're participating in the felony, and someone else causes the death of another. Because I was involved in the felony, I am also involved with it. So a little bit of different situation. Yeah.
Did you read the quote from the prosecutor? He said that this Brandon, this player, served her up.
In a sense, in every way.
That's just evil.
I mean, he was passing out condoms, okay? He didn't even know these individuals, so what?
Yeah, he was a new transfer in the Vanderbilt. These were just like his new teammates that he barely knew at all.
He was trying to get street cred. Yeah. It's just a crazy story.
Did you read that Art Briles
And
thing?
he's been convicted 2 times.
Yeah. They threw out the first one
Yeah.
because of the jury, some problem with the juror. Did you read that Art Briles story I sent you?
I did.
All right, I can't make sense of this, all right?
Sure.
The lawyer for a rape victim at Baylor says Art Briles reneged on apologizing to the said rape victim. My question is, why would Art Briles have apologized to begin with? Wouldn't that leave him open to some
All
sort?
right, so it's a kind of a strange procedural issue here. So what they were discussing was Art Briles going to a mediation, which was scheduled to try to resolve the case. All right, an all-day event that there was lots of preparation for, and a great expense because the mediators can be very expensive, especially if you do a whole day.
A mediation against Baylor.
Correct.
Okay.
Mediation against Baylor and the parties. So
Okay.
and so Art Briles is a named party. The school is a party, and the young lady's a party.